Hey guys, and welcome to today's video. Today, we have 3 sovereign citizens in court, with each one being more annoying than the last. So let's begin.
The clerk keeps our family files are difficult. Let's just put it that way. They put everything involving one couple and one family in one cause number. And it can be
Mhm.
really hard to see what's all in it.
Yes.
Like what's open, what's not. Um, Let me ask you this. Do you believe the only open issue in this case is a modification that's now back on remand? So it's live again. For a while it wasn't. Because at one point there was also, I believe, an enforcement or two filed. Those all appear to be non-suited, but I would like your thought on that on the record.
I believe that those enforcement motions were filed by the Office of Attorney General when they realized that this matter was still open and that the motion for entry of judgment still needed to be processed. They non-suited those, and I think they stand ready to re-engage on enforcement following the final entry of the judgment in this case. But that's it's really this ministerial act that's holding up those further actions.
All right, that is where I will turn to Mr. Daves, which is basically at this point, there was a lot of action at the trial court. The court ruled, did things. Obviously, I'm sure it's very present in your mind that we lost jurisdiction for a while because it was up on appeal. Um, it's back. I don't know what the delay has been. I'm sure sometimes life just is a delay in family court matter. But all this court's role is here is to follow what the mandate of the 14th Court of Appeals and issue basically a new order that follows their mandate, and that would close this case. It's very ministerial, and my role here is almost like my hands are tied with what is currently pending before the court. There's just not any discretion really with this judge's role in this particular case in this particular moment. So I want to tell you what my view of looking at the file is. I also wanted to hear from Mr. Kenny's view of looking at the file because that's important with a case that's gone on this long and has an appellate history. And so now I'll turn to you, Mr. Davis, because you said some things in the beginning that I don't really know that they make a lot of sense in this moment, in this part of this file, where we are in a procedural history in this case. I do not think that I understand how you could be arguing a special appearance. But I will obviously let you make your argument. It's confusing as to what you're claiming because we're not here at the beginning of the case, we're here at the end.
Yeah, Your Honor, does the record reflect that I'm not here to testify?
I haven't sworn you in. You're not here to testify. I mean, you can testify if you would like to be sworn in and you would like to testify, but currently you are a self-represented litigant who is making a opening statement to the court. I would hope that you are truthful, but I have not sworn you in yet.
I I accept all offers, and Your Honor, I'm just here today asking if you can give me a firm offer.
I honestly do not know what that means.
It means that even he doesn't know what he's talking about and would really like someone to offer him a coupon to the all-you-can-eat crayon taco buffet.
There is a final order that has been presented to the court from Mr. Kenny. Um, and I am in the process of reviewing it right now. My intention is to check a few more things just to make sure it's accurate with regard to what happened in this hearing, and then to sign off on it.
Your Honor, I recognize compelled performance. However, I'm unaware of any international or Admiralty Maritime contract or commercial agreement bearing my signature that would cause me to acquiesce to any demand that I make any statements. Would you present such a document before me bearing my signatures that I may examine it and honor it to the full letter of the law?
I don't need to have your signature. I need to look at the old order, which I have, the newly presented order, which I have, as well as the 14th Court of Appeals. But if you wanted to provide me with a separate document, I could look at that. But I don't think your signature is necessary.
I mean, does the record reflect that I have accepted all offers and presentments in this matter?
The record reflects everything you're saying. The words that you are saying, the record reflects. Yes.
Wonderful.
Okay.
So,
Well, I'm going to grant this motion to enter. I'm going to sign off on the order presented. I'm going to make a few changes, Mr. Kenny. I just want to let you know I tend to make some changes based on what my view, but I'm going to stick pretty close to what you presented because it looks to track what the 14th Court of Appeals remanded on, and we will get this entered, and this case will be closed. And anything else for the record before I excuse everyone?
So if you don't mind, Your Honor, just so I fully understand, I submitted two versions. The 14th Court of Appeals remand essentially gave a roadmap to the court to enter the judgment and said that the court had originally used the wrong had used guideline numbers, but Exhibit A has findings that are necessary to support that, and I just was
So
wondering
you
if
need
that's.
to put on some testimony? Is that what you're saying to me?
No, Your Honor. Everything that's necessary to support Exhibit A and that new judgment is contained in the record, and I pointed to it in the motion. So really, I don't need to put anything on if the court's
I
happy
don't
with
think
it.
you do either. I didn't think
Yeah,
you did either, but
no,
but I want to be clear, which one are you saying I should sign?
Exhibit A. The
Okay, Exhibit
yes,
A.
yes.
All right. Thank you.
Thank you very much.
Okay, so that's one sovereign citizen down and another two to come. Now, I'd like to point out that this took place in family court, so I assume that this is some sort of a result of a divorce. And I'm sure the ex-wife of his is just happy that she doesn't have to deal with this bullshit anymore. Next, we head to Michigan, where we have what appears to be a credit issue, where I assume that the defendant left his apartment he was living in, so the plaintiff was awarded alternate service and a default judgment since the credit card company couldn't find him to serve him with the lawsuit.
Midland Credit versus Lametier, 2500747.
Good afternoon, Your Honor. Violet Osk on behalf of the plaintiff, Midland Credit Management.
Timothy Antoine
Right.
by special appearance.
Do I have Timothy Lametier here?
Yes, here by special appearance.
All right, today's date and time set for motion.
That's correct.
Okay, so this is Mr. Lametier's motion. Go ahead.
Yes, I'm seeking the judgment based on the review of my documents.
I have a motion to dismiss. So I just need to know why it is that you believe that the case should be dismissed.
Defendant was never served and lack of subject matter jurisdiction.
All right, Ms. Osco?
Yes, plaintiff is relying on the documents that were filed with this court. First of all, in our response, Exhibit A, we provided proof of service via alternate service that was filed with the court, is under an oath by the process server, and according to the tracking number with the certified mail that was provided to the defendant, it was unclaimed. If you look at the sticker, it states unclaimed. And also it's handwritten on there, notified 7/31/25. And upon further review of this particular tracking number, it does state that the individual picked up at post office, according to that particular tracking number. And also may I add that this was filed with the court on June 2nd of 2025. It is the document that is titled Verification of Process Server. Our process server did verify with the postmaster a request for change of address or box holder, and it is
Objection, Your
checked
Honor.
off. May I please continue? It is
Hold on one
checked
second,
off.
hold on, Ms. Osco, I was you were interrupted there. So I didn't catch that. Hold on, sir. You will have a chance to respond to her arguments. Please do not interrupt. Go ahead, Ms. Osco.
Thank you. And also may I add that with the document that was filed with the court back on June 2nd of 2025, the request for change of address or box holder, it was checked off by the process, by the postmaster, no change of address order on file. That is all.
All right, now, sir, your turn. Go ahead.
Yeah, Your Honor, I object to everything in entirety of, and two reasons why. The first reason why is that I haven't received any competent evidence that this person has been deputized to represent the interests of the plaintiff, and I demand that this unknown person place a bond under oath for the record. The second reason is that I have not lived at that address since 2022, and I have not received any evidence of anything that this person is speaking of, and I object to all of it as hearsay. I have submitted evidence to the court that I have received a move-out letter from the Woodlands Gardens Apartments, which is the address in which the plaintiff has filed the suit or whatever the complaint is, that it matches that address to Woodlands Gardens. That is their property. I would also like to say that I have not received, to specify my standing, I have not received any copy of the complaint, and I have not received service. I have also not lived within the jurisdiction of this court, which is why I asked for dismissal by subject matter jurisdiction.
Well, you can shit in one hand and ask for a dismissal in the other and see which one comes to fruition first, especially since there was already a default judgment against you.
Any other comments, arguments, Ms. Osco?
No, basically that is the information, that is the address we had on file and we believe to be the defendant's address at the time we filed the lawsuit.
Just so I understand, it appears that this motion was triggered by the notification related to the default. There's been no judgment entered in this case at all, correct, Ms. Osco? At this point, there was a request, but there's been no judgment entered.
I see that there was a judgment entered, and that was entered on February 3rd, 2026.
Your Honor, may I speak?
I see. Hold on. I see it. Mr. Lematier, did you get their response to your motion?
I have not received any response to my motion.
It was e-filed on June 25th.
Okay. Any final arguments, sir?
I just would like to add that I don't know this person. I received initial correspondence from this person in October of 2025. From the address that I received mail from. and I've included a copy of that notice with my filing. And since that date, I have not received any correspondence concerning this matter. They claim to have served me at an address that I do not live at or receive mail from. Is entirely inaccurate, and anything to the contrary is hearsay. I have not been presented with any evidence to the contrary.
Wait, I'm confused. So you had some contact with them in October before the default was entered, and didn't file an answer or respond?
No, I have not. I've never received a complaint to file an answer or response. I have no idea what the complaint is. I've never been served. What I want to let you know is that on May 20th, I received a copy of the default request entry and judgment, and it was
Well, what happened in October?
I received a collections opportunity, a notice, I offered a contract with this person that I've never contracted with before. It was a demand for money.
Was it just a demand for money, or a demand for money that you already owed them? That is the real question.
I've included a copy of that, I believe, with my motion. Your Honor, do you understand how I've come to understand about this case here?
What's that, sir?
I said, do you understand how I've come to be aware of this case?
That's what I'm trying to ask you, sir. Those are the questions that I'm asking.
Yeah, I received at my proper address a copy of the judgment on May 20th of this year. And that's it. Which would be evidence that the plaintiff was aware of my proper address, and they never communicated with me. They never attempted to serve me or give me a copy of the plaintiff at that address. So I had no knowledge that this case even existed until May 20th of 2026. And it prejudices my right to defend against any claim against me. I also do not live within the jurisdiction of the court.
I apologize, Ms. Alston. I'm trying to put the pieces together where the efforts were made to serve him.
Your Honor, may I add that we did finally obtain defendant's P.O. Box address, and that is how he was served with the entered default judgment. I believe
Objection,
that's
Your
what
Honor.
the defendant is referring to.
Objection, Your Honor.
What is your objection for?
That's hearsay, sir. My first communication with him was on October of 2025, and that communication contained the address, which they ended up sending me the default. So they knew what my address was.
So, sir, that's why I give you another chance to speak. The objection would be if there was something that was legally improper for her to put on the record. That's her argument, then you'll get a chance to do the same. And if last time I checked, every single time that you have something to say, she doesn't interrupt you. So just hang on a second. All right. I always give people a chance to respond. So Ms. Osko, please, again, before you were interrupted, I just wanted to understand. So, so there was at some point in time the obtaining of this P.O. box.
Yes, that is correct. We filed with this court on April 27th of this year, proof of service that we did mail the default judgment to the defendant at the P.O. box.
And is that just so I understand, is that the first correspondence through this entire time that has ever gone to that P.O. box?
Yes.
All right, so Mr. Lematier, it's my understanding, because you had indicated that you didn't get a copy of their response. I just want to make sure you knew that it went into they e-filed it, and so that might explain things. I don't know for sure that whether or not it was sent to you, it was made available through e-file. But long story short, a motion to dismiss is not appropriate at this stage. Now, if you had provided this court a motion to set aside a default, I certainly would take a look at that. But there's not a basis. There's not a basis for me to dismiss their case. I can. What I could do again. I can't give you advice, sir. I'm denying your motion to dismiss, but I'm telling both parties that if he presents to me a motion to set aside the default, I would consider that and hear any arguments related to that. And then if I reinstated the case, any motions related to venue and all that kind of stuff, I would certainly take a look at that, sir. But a motion to dismiss their case, I don't have a basis for that right now. But I'm indicating, so Ms. Osco, so you can be prepared as well. If he does decide to do a motion to set aside this default judgment, I can certainly take a look at that and we can go from there.
Yes, sir. It's stated within the relief. It states it asks that you set aside the default judgment.
But your motion was titled motion to dismiss.
Yes, it asks for you to set aside the judgment and dismiss the action, sir.
Well, you might have an argument for setting aside the default judgment, but you won't be getting a dismissal today. That would require a new hearing. Now, I do find it funny that all of these sovereign citizens play stupid until these credit card companies start getting their money back through wage garnishments. Then all of a sudden, they're ready to have a hearing.
Okay, so I actually don't have an issue with giving Mr. Lematier a chance to, now that there was a proper address, he did respond relatively quickly to that. I do note as well, Ms. Osco, that there was periods of time where this case actually got to the point where it was going to be dismissed for failure of progress on the file. So we have Mr. Lematier here. We can get to the bottom of these issues. So the motion to dismiss is denied. The relief that's requested to set aside, I'll grant that. Defendant is to file an answer within 21 days. The court will set a pretrial. If the defendant fails to file an answer, the court will reinstate the default judgment.
I'm sorry, sir. Are you saying you're going to give me a chance to review the complaint?
I'm giving you a chance to, yes, you should get a copy of the complaint. Ms. Osco, you have his address now. Send him a copy of the complaint. The PO box is a good address, correct?
Yes, I submitted the correct address.
Okay, so you'll get a copy of the complaint, and then within 21 days of receipt of that, you need to file an answer. If you don't file an answer, then the court will move forward for a default. You seem as if you are serious about challenging this case. If you are, then I would expect an answer within 21 days. The answer I would expect would contain all the other challenges that you brought up today as reasons why that there shouldn't be a case against you on behalf of Midland Credit. So I'm giving you a chance here, sir, to litigate your case. And then Ms. Oscar we'll see what he has that is serious, and then you can talk to your client about, whether ultimately he's brought up a venue challenge here, whether we can look at all those things.
Okay. Will the court be entering such order, or shall the plaintiff submit one for a court's entry?
If you could submit one, I would appreciate it.
Okay, will do.
So, sir, you should look for the, does seem to be some issue with understanding e-filing. So if you send him a copy of the complaint again, and then that way you can answer it, Ms. Osco.
Yes.
All right, sir. Do you understand what the court's looking for from you?
The court is expecting me to receive a copy of the complaint and to file an answer within 21 days.
Yeah, 21 days of the receipt. So don't worry if it takes a week to get to you. You haven't lost 7 days. Once you receive it, you got 21 days. Then we'll set it for a pretrial, and then we can get to the business of resolving this case.
I understand.
All right. Thank you both.
Thank you.
All right. Thanks.
All right, so he won his set-aside request. And now they're going to have a new hearing where I'm sure he's going to argue that because there was no signature and he never contracted with any of these companies, that he doesn't owe the money, even though he used their credit cards to buy his edible glue sticks. It's not necessarily a win for him, just a prolonging of his eventual and final loss in the matter. Now we head to our final soft-heart of the day, who refuses to be sworn in, so the judge refuses to take his testimony.
Mr. Taylor, do you represent Progressive in this one?
I represent the MEIPF.
Oh, okay. So the moving party is not here.
What case is this?
This is Hanson?
Okay.
No? Okay. Then sit tight, everybody.
I represent Progressive in the Leonard Hanson case.
Yes. All right. So are you ready to go, Ms. Jabori?
I am.
Okay. Give me 1 second. Mr. Hanson, take off whatever is covering your video. Thank you. Perfect. All right, calling case number 25-006443, Leonard Hanson versus auto owners. Appearances, please.
Jabori on behalf of Defendant Progressive.
Morning, Your Honor. Wesley Taylor, P86303, on behalf of Defendant MEIPF.
Okay, Mr. Hanson, state your name for the record, sir.
Your Honor, I have some preliminary issues that I had questioned with you about.
Mr. Hanson, state your name for the record, sir.
My name is Leonard O'Neill Hanson, trustee of the Hanson Family Private Trust. I'm moving in fiduciary capacity.
All right. Okay, go ahead, Mr. Jabori. This is your motion for summary disposition.
And I know the court went through the filing that, the briefing that we filed, so I'm just going to be pretty brief. It's a simple issue. The Progressive policy at issue here was canceled on February 5th, 2025 at 12 a.m. due to non-renewal. The accident occurred February 5th, 2025 at 2:28 a.m. as confirmed by the police report. Per the plaintiff, in discussions that he had with our claims department, he found a cheaper rate with Auto Club. So he switched his auto insurance with auto owners. So he switched his auto insurance to auto owners on the date of the accident. The Progressive policy was never renewed. So Progressive is seeking dismissal in this matter as a result.
Okay. I did not receive a response. Did you see a response in the system, Mr. Jabori?
Did not.
Okay. Mr. Hanson, did you intend to file a response? Because I did not see one in the system.
I understand that a motion was filed by Progressive and that it was supposed to be heard on the 24th. However, again, I have preliminary issues that need to be addressed before anybody can be making decisions on this case. Like for example, I want to start at the beginning. Last week we had an issue about me recording or so-called protecting my interests, and that screen recording was somehow muted and I was unable to obtain your P number for one. Like you had stated your P number on at that time, which I was asking my questions, and somehow the recording sound got deleted. So if I may, can you please provide me your P number first?
Yes, Mr. Hanson, my P number is 68588. But here, let me swear you in. Raise your right hand, sir.
Nobody else swore in.
I'm swearing you in right now, Mr. Hanson. You won't get sworn in?
Will anybody else get sworn in?
Mr. Hanson, I have some questions for you. Please raise your right hand.
I'm asking
Mr. Hanson, I have some questions for you.
I don't consent.
You said that you were recording something. I instructed you to stop. We are on the record now. So
okay,
I would like to know whether you made a recording. You just said you did.
Yes, I agree. We both agree.
Raise your right hand, Mr. Hanson.
Am I entitled to defend myself?
Mr. Hanson, raise your right hand.
What am I raising my right hand for?
Because I'm going to swear you in. If you're going to testify on the record, you're going to be sworn in.
Is anybody else Are
They're
you?
not testifying. They're arguing. You are
Didn't
testifying, Mr. Hansen.
they're presenting motions and whatnot. We have not even been allowed to stand before the
Mr.
court.
Hansen, you are testifying.
I'm not
Raise your
testifying.
right hand.
I'm not testifying.
You're not testifying. Okay, then stop talking.
I'm
Stop
asking
talking.
questions.
Let's argue the motions. Let's argue the motions.
Can
Do
I
you
get
have
your
any proof, as we sit here today, that there was an active progressive policy?
I got a whole lot of proof.
Okay, where is it? Show me.
Can I have your P number first?
Well, if you pulled your head out of your ass and stopped running your pain eater, you might have heard her already give it to you. And just look at the other lawyer on camera. He has literally been facepalming ever since this jackass started talking.
I already told you, Mr. Hansen.
Okay, I didn't get a chance to write it down.
68588. Where is your proof that there was an active progressive policy?
88. Again, I have other preliminary questions before any motions are heard.
We are here for the motion, Mr. Hansen. Let's deal with the motion, then we'll get to your issue.
I don't accept anybody filing motions that don't have authority, that's not delegated authority under, for example, under a corporation can neither practice law nor hire lawyers to carry on the business of practicing law. For it, People versus California Protective Court 76 Cal App 354-244 Pack 1089.
Mr. Hansen, I'm going to ask you one last time. For the record, and we are on the record this time.
Yeah.
I looked in the Register of Actions. I didn't see a response from you. I'm asking you now, what proof do you have that there was a progressive policy active at the time of the accident? What proof do you have? Even though you didn't file a response, I am giving you the opportunity to show me some proof right now.
The deceased party had progressive in this case, which is, what's the guy named? Brandy Pierce had progressive. And you didn't allow Christopher Gotza of the Lee Steinberg office to remove himself as my attorney, who was delegated authority, which I can say that I signed up for, that allow him to have power of attorney. You allow him to remove himself without even giving me a response in writing. Like, I never received your ruling on that in writing, for one. That is the issue, procedure. And Mr. Gotza, in my opinion, has committed bad faith. Him and his assistants having, conspired with progressive so-called attorneys that can't even represent Zachary R. Morgan, P81865. Like, if he was one of the initial parties in this case that was representing progressive. And the issue that I'm having with that is that he using a PO box for service under MCR 7.207A. Attorneys must have an actual address for service. And that's it's not limited to that. Like, it's a lot of conspiracies going on against my rights, and it consists of these attorneys acting on behalf of corporations that they can't represent. Like, so-called being here today for a motion. This woman that's speaking for progressive today, how was she delegated her authority? Like, can Zachary R. Morgan just delegate authority to her? Like, this is my first time hearing her. She's a surprise attorney, you understand? And again, all the parties are not present today. Like, no, I have not heard anybody here that's representative of the deceased party, Brandy Pierce out of Ohio. That's an issue. Also, these attorneys that's representing these corporations are not allowed to do so without how was their authority delegated to them? You understand?
The same way the authority is delegated to a lawyer representing a non-corporate entity. In fact, it is against the rules of procedure for a corporation to represent itself in a legal matter, and they must hire a lawyer to do so according to a 1937 Michigan Supreme Court ruling in Detroit Bar Association v. Guardian Trust, and reads as follows. While an individual may appear in propria personam, a corporation, because of the very fact it's being a corporation, can appear only by attorney regardless of whether it is interested in its own corporate capacity or in a fiduciary capacity.
And then doing business as the Third Judicial Circuit. You say you here represent the Third Judicial Circuit as the lawyer. I mean, as a judge. It take you 5 years to become a judge, a licensed, like you got to practice law for 5 years. Is that correct?
Yes.
And if you know better than anyone, is that it's a difference between having a license and a certificate. You guys are all representatives
Mr.
of
Hanson,
the
I'm going to
state.
ask you one more time. What evidence do you have that there was an active progressive policy on the date of the accident? That is what we're here for.
Yeah, but the parties that are here don't have delegated authority. They don't have the right to file any motions.
So is your answer none? Is your answer none?
I'm telling you that the motions filed on behalf of Progressive is to no avail. Like, they are representing corporations that they can't represent. They can't file a motion for Progressive. But more importantly,
Mr. Hanson, is your answer none?
I had Progressive. Me and my common law wife had Progressive. Mr. Gotza is aware of that.
Remember, you wouldn't swear in. You can't testify to that. So give me some admissible evidence. You wouldn't swear in. Give me some admissible evidence that you had a progressive policy.
The deceased party had Progressive as well, Brandy Pierce out of Ohio. And also, it's bad faith with
I can't take your word for it, Mr. Hanson. You wouldn't swear in.
Nobody swore in. You taking motions from people like that don't qualify to. How was their authority delegated to them? Like, that is the issue. You understand? You accept motions for people that don't qualify to represent a corporation.
Okay. Ms. Jabori, pursuant to, let me pull this up. I believe it's MCR 2.119G4, but let me make sure so I can state it on the record.
Are you going to swear yourself in under oath?
Are you going to stop smoking a blunt in court, regardless of whether you are under oath or not?
I'm not giving testimony. 2.116G4, we have no response filed by the plaintiff. I have no evidence presented by the plaintiff to establish a genuine issue of fact that there was a progressive policy in existence at the time of the accident. Therefore, I'm granting your motion. You're out. Submit an order. Looks as though we have another motion hearing up next Friday. Oh, that one's being decided on the pleading. So with respect to the settlement conference, I'm going to adjourn this until after we decide that. Let's do 30 days. So the settlement conference is going to be adjourned. Ms. Jabori, put this in the order, even though your client's out, just so that we don't have to have multiple orders on this. Settlement conference is going to be adjourned to August 20th at 10 a.m.
I'll get that submitted to me.
Thank you.
Thank you, Your Honor.
All right. Mr. Taylor, did you have anything else?
No, not.
Mr. Jabori, did you have anything else?
No, I do not.
All right. You're free to go.
Thank you.
I have something else.
Nope, we're done, Mr. Hanson. Don't disrupt my proceedings. I'm muting you. If you continue to talk, I'm going to put you in the waiting room.
Well, he continued to talk, but the judge muted him, so nobody had the displeasure of listening to his horse shit. Alright guys, that's the end of the video. If there are any follow-ups to the last two idiots, I'll be sure to let you know. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.